Okay, good morning, class. Today I'm going to be covering your syllabus. So if you all can get your syllabi and we can cover that. I'm going to be reading it and then I'm going to go into a little bit of speed building, okay? So this is CRTR 2403, Fall 2017, El Paso Community College Syllabus Part 1, Instructors Course Requirements, Fall 2017. CRTR 2303, make sure you're in the right class, Advanced Machine Shorthand, Distance Learning Online, and there are no in-person class dates. So faculty information, I'm Lucretia Thomas, CSR Certified Shorthand Reporter, RPR Registered Professional Reporter, and CRI Certified Reporting Instructor. This is the Northwest Campus, room M84, where I'm located. My office number is 831-8834. Leave a message and I'll get to you as soon as possible. My email, which is the preferred way of corresponding with me, is lucretiat@epcc.edu. Make sure that you leave me a message with your email, with your name, the information, and I should hopefully get back to you as soon as possible. Remember, I will communicate with you through Blackboard. I will send messages, announcements from time to time. I check off the email box that you all hopefully can get an email as well sent to you, but just check it frequently because that's the way I make class announcements, so make sure that you're on top of that, okay? Office hours will be using Zoom. This is Zoom, where you call in with my cell number, and it's through Zoom Us. You should have received an email regarding it. My office hours will be 1 to 2 Mountain Standard Time, Monday through Thursday, Fridays by appointment. My cell number is 915-274-2521 if you need to contact me. And the description of the course, this covers conflict-free machine shorthand theory in depth and continuous skill building through readback of dictation notes, machine practice, and transcription. To exit this course, students must write on a stenographic machine and pass at a minimum speed of 160 and 140 with 97% accuracy on 2 5-minute time writings each on Q&A material, and pass 2 5-minute time writings each on 140 words per minute and 120 words per minute with 97% accuracy on jury charge material, and pass 1 5-minute time writing each at 120 and 140 with 95% accuracy on the multi-voice material, and pass 2 5-minute time writings each at 120 and 140 with 97% accuracy on lit material. Technology requirements: you must have a computer. You need either a desktop or a laptop that connects to the internet. It is highly recommended that Windows 10 be installed if you do not own a computer, or if your computer malfunctions during the semester, you will be expected to identify a computer to use. Computers are available at the library and at various EPCC campuses. Technology problems are not an excuse for missed or late work. Blackboard, mandatory that you contact 915-831-6440 as soon as possible to receive a username and password for access to Blackboard. Please have your student ID number and let them know that you are an online student. Your username and password are required for access to Blackboard. All assignments, labs, and lectures will be accessed through Blackboard. Please be sure to use Google Chrome or Mozilla Firefox as your browsers when using Blackboard for the best internet connection. Very, very important, you also use Firefox or Chrome as your browser when you're logging into Blackboard. I promise if you don't, it'll be such a problem. It throws you out of Blackboard or you can't hear Blackboard. So make sure that these are your browsers. Stenographic machine requirement. I know most of you already have your machine, so I really don't think I need to cover that. If you need to rent one from us, let me know. Call us at the lab. 831-8879, 831-8860, okay? Software requirements. Case Catalyst is the software that is available to you all here at the lab free of charge, but if you can't make it in, I know that Stenograph has some great prices where I believe you pay $100 every 3 months, and I believe it's 6 payments, and it's very, very, very reasonable. I think it's more reasonable than if you rent from us, because we do rent the software and the machines to the theory students, but it's $200 a semester. So $100 is a great price every 3 months. Lab assistant information. Your lab assistant for this class is Kat Santibanez. Her email is kblancha@epcc.edu, and she can be reached at 831-8879 or 915-831-8860 if you have any questions, okay? Our hours are 9 to 5, Monday through Thursday, and then, of course, Fridays we're closed. The textbook is optional, and it's for your written knowledge tests. And so you have the National Court Reporters Association, how to prepare for the RPR, RMR exams, and to practice questions for the RPR, RMR exams. It's sold as a package, 1998 version. It's available at the EPCC bookstore. But the next books are what we really recommend. It's the Court Reporter Reference Textbook, Workbook, and Study Guide by 4 books, Monet Benoit and Emmett J. Donnelly. It's 4 books, and I'm always reading how these books really help the students pass their written knowledge tests. So make sure that you all, if you need to order them, that you get on that now. It really makes a difference to start reading the books now. And remember, when you take your written knowledge test at the state test level, it counts for life, okay? It's always good for life. So once you pass it, it's there forever. And then you can just focus on the machine. The Uniform Format Manual for Texas Court Reporters, 2010 edition. That's in Blackboard under handouts. And remember, those are sample sheets of how your transcript should look when you become a court reporter. So we highly recommend that you start using them now if there's something that comes up and you don't know how to write it on your transcript. Very, very important, okay? So the materials for this class, you need to have a stenographic machine, software. You could either use Case Catalyst or Eclipse. You need a dictionary. We recommend the Merriam-Webster's 11th edition paperback dictionary. It's very inexpensive, but this is what the state test uses to grade your test. So that's why we use them, okay? USB flash drive so that you can record from whatever's in Blackboard. You can download it and have something to practice to. And then you've got you need to register with EV360 software. Username and password will be given to you. It's in Blackboard. It's on the left tab, and it's EV360. Make sure you watch the demo that's in there so that you get explanation of how you get your password and username. Very important this semester because you're going to have to do some homework in there, okay? It's all speed building. It's all going to help you all out very much. The course requirements, evaluations to pass this class. You have to pass 5-minute time writings, 2 at 120 and 2 at 140 with 97% on lit. Pass 2 5-minute time writings at 120 and 142 each with 97% accuracy on jury charge. And then you have to pass 2 at 160 and 2 at 140 with 97% on Q&A. And then you have to pass 1 140 and 1 120 with 95% accuracy, multi-voice, okay? Grading scale, attendance will be verified by Blackboard, and class must be attended 80% of the time. So if you have 12 absences, that's 80%. 13 takes you over, and you will be dropped or given an F in the course. So make sure that you realize that. In order to get an A, you have to pass all your required time writings for this class, which is 14, plus 95% of homework notes and 95% of dailies turned in. B is 75% of your required time writings, which is 11. I have it highlighted there, plus 90% of homework notes and 90% of dailies turned in. And then you have 50% is another option, or you can have 50%, which is 7 tests typed and passed, plus 95% of your homework notes and 95% of dailies for a B. A C is 50% of required time writings, which is 7 passed, plus 85% of homework notes and 85% of dailies turned in, or 25% of required time writings, which is 4 passed, plus 90% of homework notes and 90% of dailies turned in. D, 1, 2, or no required time writings passed, but you still have to get 80% of your homework notes and 80% of your dailies turned in, okay, for a D. And that's to keep your test that you did pass. An F is you didn't pass anything and you didn't turn in at least 80% of your homework notes and 80% of your dailies. Note, all required tests or time writings must be passed before the student will be allowed to enroll for CRTR 2435, which is the next class, or unless a grade of I is given. Remember, you don't want to go on to the next class unless you're prepared to go on. So you really don't want to do that, okay? Average grade, 90 to 100 is an A. 80 to 89 is a B. You've got 70 to 79 is a C. 60 to 69 is a D. Below 60 is an F. Homework and dailies under C. Notes from 15 hours of practice hours are required per week. Refer to your practicum guidelines sheet under handouts as how to complete your homework. 5 hours of homework is mandatory in EV 360. Please send your homework and practicum guidelines sheet via email to your lab assistant, Kat Santiavanes, kblancha@epcc.edu, and carbon copy Lucretia Thomas at lucretiat@epcc.edu when using computer-aided software. The homework is due every Monday. 15 extra lab hours and 3 dailies will be added to your homework totals at the end of the semester. So every semester I give you 15 hours of homework, lab hours, and 3 dailies at the end of the semester. So don't worry if there's 1 week you didn't turn it in. No, I always give you that at the end of the semester. The homework notes for this class for 15 hours of practice average anywhere from 300 to 450 pages. This is just an approximation. Should there be any question regarding your homework hours, you should be able to demonstrate to the instructor how you arrived at your weekly total. No more than 20 hours will be accepted at any one time, especially at the end of the semester. The homework and/or lab hours to be turned in shall be done according to the practicum guidelines. So very, very important that you all realize that you need to complete 15 hours of practice, and 300 to 450 pages is what it totals out to. I understand it may deviate, but this is what we're looking at for full practice of, listening to a 5-minute tape. Okay, so this is what we go based on. Some of you I know are not turning in that amount, so please make sure that you realize that that's what the pages amount should be. Homework notes that are completed utilizing court reporting software must be emailed to Kat and carbon copied to me. If you are using Case Catalyst, the best way to send your notes via email is you open the Case Catalyst, and so I explain how to turn them in. 3 transcriptions of time writings, dailies required per week. Tests must be typed in their entirety and may be typed at home if not to be graded. Dailies must be turned in weekly. Dailies must be turned in by September 14, October 12, and November 9, 3 per week. This is to ensure dailies are being typed up during the semester. Any dailies not turned in during this time period will not be allowed to be turned in at the end of the semester. And your dailies should be turned in utilizing computer-aided transcription, Case, or Eclipse. Remember, you all, the dailies, the purpose of those is to look at your notes, see what you're writing, and make entries into your dictionary. Some of you are turning in your dailies and they're not translated properly. You need to look over them and make any changes, clean up your work, and see what you're writing, okay? Please, very important. D, makeup exams. A student has 1 week to access Blackboard. Extra credit assignments may be done as per the instructor. A student may receive no more than 20 extra credit hours per semester. So if you want extra credit, just see me and we'll be able to work something out. F, Blackboard recordings. Please call 915-831-6440 to obtain your username and password for access to Blackboard. Tell them you are an online student. Attendance will be verified through Blackboard. All activity is monitored. And if you're not accessing Blackboard at least 80% of the time, you have 13 or more absences, you will be dropped or given an F. Okay? Students must access Blackboard recordings on a daily basis. Students will not have access to the Blackboard recordings after 1 week has elapsed. This will be strictly enforced. Any tests typed after the 1 week period will not count as a pass. Make sure that you keep track of Blackboard, that you're not accessing, that you are accessing it. If you log on with me, I will keep track. But if you don't, you need to log into Blackboard and make sure that you realize you only have 1 week to access everything. If tests are typed at home and it's a pass, please email your notes to your lab assistant the next class session, or the test will not count. Instructors' policies, attendance drops. Please call 915-831-6440 to obtain your username and password for access to Blackboard. Tell them you are an online student. Live class will be from 11 to 11:50 a.m. Mountain Standard Time. So if you want to join me, it's not required, it's optional. But if you want to read back, the instructions are on here, how to access through your phone. And remember, the ID number is always my cell phone number, okay? Withdrawal from class, it is your responsibility to withdraw from the class in accordance with community college's policies, procedures, and timelines. The instructor may drop any student who does not access Blackboard. The last day to withdraw with the W is Thursday, November 9. I grade, the grade of I incomplete will be given solely at the instructor's discretion. Such factors as attendance, number of tests needed, homework completed, etc. will be given consideration. You are allowed 4 months to complete the time writings. Should you choose not to re-enroll for the same course, the following semester you will have to make arrangements with the instructor to take the time writing tests. D, student conduct. Cheating will not be tolerated. Any student in violation of the Code of Student Conduct will be reported to the Vice President of Student Services. Persons who are caught could be subject to community college sanctions as well as being given an F on the assignment. Students' notes may randomly be audited on past tests. This is to ensure the integrity of online testing. E, student responsibility. Misunderstanding or confusion should be communicated to the instructor. Students have the primary responsibility for asking for help in completing the course objectives and in seeking assistance when needed. Students are encouraged to keep their own records of dailies and lab hours turned in. And so we have the lab area conduct, and I won't read that since I don't think any of you will be here. G, I do want to cover G. To carry over past time writings from one semester to the next semester, the student must, so if you want to keep your test that you passed this semester, you have to come the next semester, and you have to get at least a D in your class in order to keep those tests, okay? The calendar for this class, Mondays, we're going to have jury charge, speed building at 120 and 140, and then tests. Tuesday, Q&A, speed building at 140 and 160, and tests. Wednesday, lit, speed building at 120 and 140, and tests. Thursday, multi-voice speed building at 120 and 140 and tests. Last day to withdraw with the W is Thursday, November 9. Week 16 is finals, December 4 and 5. Roll will be taken through Blackboard. You'll get 2 examinations of each speed test, and I will make an announcement in Blackboard as to how your test will be given. This calendar is subject to change. The certification exams and written knowledge exams, I have that information there in case you want to take your written test. It's through JBCC and TCRA. The next exam for the machine portion is not announced yet. They don't have a date, but that's all the information if you wanted to go ahead and take your written test. Withdrawal policy. Beginning fall 2007, all freshmen enrolled for the first time at any Texas public college or university will be limited to 6 course drops during their entire academic career. Drops include those initiated by the student or by faculty and those incurred at other Texas institutions. This policy does not apply to courses dropped before census day or to complete withdrawals from the college. When you register, see your advisor, choose your courses carefully. Before you drop a course, see your advisor, discuss options with your professor, use campus resources such as tutoring labs, computer labs, etc. So this only pertains if you're in Texas. So you're allowed 6 drops with the W. After the 6th, it becomes an F. So very important when you're in court reporting classes, because we do tend to drop the classes because we can't meet all of the requirements. So make sure you keep that in mind. On your official syllabus, the 2nd page under 5, Disability Statement, Americans with Disabilities Act, ADA. I want to read that to you. EPCC offers a variety of services to persons with documented sensory, mental, physical, or temporary disabling conditions to promote success in classes. If you have a disability and believe you may need services, you are encouraged to contact the Center for Students with Disabilities to discuss your needs with the counselor. All discussions and documentation are kept confidential. The offices are located here at the Northwest Campus, room M54, and the number is 915-831-8815. Okay, so just in case any of you wanted to know. So I will get ready then for some speed building. Please don't hesitate to ask me any questions. I am available. Send me an email, and let's get ready for your speed building, okay? Okay, class, so what I'm going to do is I'm going to give you a little bit of speed building. I will go ahead and do 150, okay, before your test. So this is going to be at 150 before your test, okay, speed building. Like I said, call me if you have any questions regarding anything. Here we go. Ladies and gentlemen of the jury, ordinarily in a case of this kind, there is no mention made of insurance. However, insurance has been mentioned several times, and since you are aware that there is a claim in this case, let me tell you what emphasis it should be given. Of course, there is a great temptation on the part of the counsel for the plaintiff to bring before you, members of the jury, the fact that the defendant is insured. However, by doing this, the plaintiff may be guilty of error or possibly prejudicial error, which might require the granting of a motion for mistrial or the granting of motion for new trial. In the event that plaintiff prevailed, or in the latter event, a reversal on appeal. Ordinarily, and as a rule of thumb, no mention whatever should be made of insurance. Occasions where it is essential to develop an admission coupled with a reference to the fact that insurance exists are admissible. In such a case, it appears that the evidence is not developed for the purpose merely of bringing into evidence the facts of insurance and error is committed. For example, if a defendant made the following statement, "My insurance company will pay for all of your damages because I'm entirely to blame," that would be a proper admission because the whole statement is necessary. A witness may be impeached by contradictory evidence, by evidence that his general reputation for truth or integrity is bad, by evidence that he has been convicted of a felony, or by evidence that on some former occasion he made a statement or conducted himself in a manner inconsistent with his present testimony. The impeachment of a witness in any of the ways I have mentioned does not necessarily mean that his testimony is completely deprived of value or that its value is destroyed in any degree. The effect, if any, of the impeachment upon the credibility of the witness is for you to determine. In respect to any attempt to impeach a witness not party to this action by showing that on some former occasion he made a statement or statements that were contradictory of his testimony here, you may consider the evidence of such a contradictory statement only for the purpose of testing the credibility of the witness, not for the purpose of proving the truth of the statement. When the witness whose impeachment in this manner is attempted is a party to the action, if the asserted prior statement constituted an admission against interest, evidence of statement may be considered in determining the truth or falsity thereof, as well as for the purpose of testing the credibility of the witness. When the law says that one person has a right of way over another, its purpose simply is to establish a practical basis for necessary courtesy on the highway. And its meaning is that when at any given moment, two persons, neither of whom then occupies the space in question, desire to proceed into the same place on the highway, one of them shall yield. The other has the privilege of the immediate use of the space in question. That privilege is his right of way. Failure to yield to one to whom the law has given the right of way is negligence, unless circumstances resulting from causes beyond his control are such an excuse and justify him in such failure, judging his conduct in the light of what reasonably might have been expected from a person of ordinary prudence. In providing that one person has a right of way over another or must yield the right of way to another, the law refers only to this kind of situation. If two users of a highway were to proceed without delay on their respective courses, a danger of collision would exist. You must still keep in mind that no question of right of way arises until an actual conflict exists in the desires of two or more persons to enter into the use of a place on the highway, not then occupied by either or any of them. Section 2301 of the California Vehicle Code provides that any person who is under the influence of intoxication, liquor, or who is under the combined influence of any drug and also liquor, who is driving a vehicle and during the driving of such vehicle violates any law or neglects to do or perform any lawful duty which action or lack of action proximately. Okay, and so we'll get ready for your tests. So make sure that you clear your memories, you all. I know it wasn't much speed building, but tomorrow we'll have more speed building for your Q&A, okay, since I don't have to cover the syllabus. Okay, so we have on your test number 1, Miss Arnett and Miss Kiefer. Okay, this is 140 test number 1. And here we go, you all. This is going to be 140, number 1. Members of the jury. Each of the parties in this case is charging the other with the violation of the statutes which relate to negligence in the operation of their vehicles on a public roadway. The rules and laws of the state are very precise in what constitutes negligence. It is stated that on a violation of any of the laws by a person operating a motor vehicle on a public highway or roadway is evidence of negligence. The presumption of negligence can be rebutted by evidence showing that the particular statute in question was not violated, or by evidence showing a reasonable ground for the violation in question. Members of the jury, a driver of a motor vehicle is required to use the same care and caution while driving that anyone in that same situation would use. They are expected to use the care and caution that the situation on the highway or roadway demands. The factors to be considered in deciding whether or not a driver was negligent are many, but 2 of the primary factors are the speed at which he or she was driving the vehicle at the time of the accident and the control he or she had of the vehicle. In deciding whether or not the driver of a motor vehicle was negligent in the operation of the vehicle, you should also take into consideration the visibility on the highway or roadway on which the vehicle was being driven and the weather conditions on the night in question. Although it does appear that both the plaintiff, Ms. Arnett, and the defendant, Ms. Kiefer, were driving the required speed limit at the time of the accident, that alone does not remove the possibility of negligence on the part of the defendant and contributory negligence on the part of the plaintiff. Regardless of the fact that both Ms. Arnett and Ms. Kiefer were driving under the maximum speed limit for that section of the roadway, it is still the duty of each of them to use the care and caution that an ordinarily cautious person would use under the same or similar circumstances. It is the duty of the driver of a motor vehicle to keep their vehicle in their own lane of traffic and to drive responsibly. Our laws state very clearly that the driver who is entering an intersection with a green light doesn't have an unqualified right to proceed. That might come as a surprise to you, ladies and gentlemen, as it often does to a jury panel. We are all guilty of assuming that if a light is green in our favor, then it must be safe to proceed. But the law states that our right is not unqualified, which means that the driver is obligated to exercise reasonable care for observing the traffic conditions at the intersection. Now, we don't mean to imply that a driver proceeding through an intersection on a green light has the same duty as the driver at a stop sign would have. What it means is that the driver who has the green light in his or her favor is still required under the law to make reasonable observations of the traffic situation. Depending on the circumstances, you can then conclude that the driver acted reasonably if he or she made basic observations before proceeding. The failure of a driver who has the green light in their favor to use such care while proceeding through the intersection is evidence to be considered by the jury in determining whether that driver was negligent in the operation of his or her motor vehicle. Members of the jury, you are the sole judges of the truthfulness of the witnesses, and it will be up to you to determine which you find credible and which you don't. You will give to the testimony of the witnesses the credibility and the weight that you think it deserves. If you should find from the evidence that as the car that the plaintiff, Ms. Arnett, was driving approached the intersection in question, that the car was under her control and she was using the same care that a person of ordinary judgment and caution. And then we have your second, 140, Equal Pay Act, and that's it, Equal Pay Act. So this is going to be 140, number 2, for 5 minutes, jury charge, okay? And it starts in the middle. Members of the jury panel. As the exclusive judges of the facts, you must decide which of the witnesses you believe, what part of their testimony you accept, and what weight you attach to it. At times during the course of this trial, I may have sustained objections to questions asked without allowing the witness to answer, or where an answer was given, I may have directed that it be stricken from the record and that you disregard it and dismiss it from your minds. You may not draw any inference from an unanswered question, nor may you consider testimony which has been stricken in making your decision. The law requires that your decision be made solely upon the competent evidence before you. Such items as I exclude for you to consider are excluded because they're not legally admissible. The law does not, however, ask you to accept all of the evidence I shall admit, even if it may be competent. Evidence can be direct or circumstantial. Direct evidence is evidence which, if believed, confirms a fact. Circumstantial or indirect evidence is evidence which, if believed, proves a fact, and from that fact you decide by logic and reason that other facts exist. I may at some point in time refer to some certain evidence in this case. I do not plan to refer to all of the evidence in this case. I do not intend to imply that one certain element of evidence is to be given more weight than another. Now, the evidence that I do refer to is not the only evidence that you should consider when you return to that jury room to deliberate on the case. You are responsible for all of the evidence in the case in reaching your verdict. That is your duty. My duty as judge is to decide questions of law and then to deliver your instructions as to how the law applies to the evidence presented in this case. In this matter, the plaintiff claims that the defendant breached a federal law known as the Equal Pay Act. Under that act, it is unlawful for an employer to distinguish between employees on the basis of sex by paying different wages for similar work on jobs requiring equal skill, effort, and duty, and which are performed under like working conditions, except where such pay difference is based on any issue other than sex. If you find in favor of the plaintiff, you will then consider the issue of plaintiff's damages. In that regard, you should award the plaintiff an amount of money that will fairly and completely compensate her for the damage the evidence shows she has sustained and is reasonably certain to sustain in the future. In a few moments, you will retire to the jury room to start to decide the case at hand. It has been a long trial, and I am grateful for the close attention that you have paid to what all of the parties said. There is no greater civic duty than to serve on a jury. At every break and at the end of each day, I told you not to discuss this case among yourselves or with others. I did that because I wanted you to hear all of the evidence before you began to confer with your fellow jurors about the case. You have now heard all of the facts and the evidence, and it is time for you to deliberate this case. The initial order of business when you go into the jury room is to choose one person from your group to act as your foreman. It is your duty as jurors to discuss the case with one another in an attempt to reach agreement, if you can do so. Each of you must decide the case for yourself, but only after full consideration of the evidence with the other members of the jury. While you are discussing the case, do not hesitate to question your own opinion and change your mind if you become convinced that you were wrong. But do not give up your honest belief solely because the others think differently or merely to get the case. Okay, and so we have 120, number 1. Let's get ready for those. You have Ms. Ullman and Mr. Schaefer. And that's it. This is going to be 120, number 1. And I also see August in there, okay? 5 minutes. Today is August 24, 2015. And we are going on the record. This is a case brought by the plaintiff, Ms. Ullman, who states that she was discriminated against by her employer, Mr. Schaefer, due to her disability. Ms. Ullman, the plaintiff, claims that Mr. Schaefer took employment action against her and that it was because of her disability. Ms. Ullman claims that she was terminated from her job because the defendant, Mr. Schaefer, felt that her disability prevented her from doing specific duties that the job required, when in fact she was capable of successfully performing the work if she had been given accommodations. To succeed in this case, Ms. Ullman must prove her claim by a preponderance of the evidence. In order to decide what the details of a job are and whether or not Ms. Ullman was able to successfully perform the specific duties of her job, you may consider the employer's judgment as to which functions of the job are essential and the amount of time spent on the job performing the functions in question. You may also take into consideration the work experience of people who have held this job in the past and the current work experience of people who have the same job as the plaintiff. You will consider all of the evidence in the case to determine whether the specific function of that job is essential. The fact that an employee is unhappy with something his or her employer did or failed to do is not enough to make that act or omission an adverse employment action. It is your role in all of this to determine if the defendant, Mr. Schaefer, is at fault by discriminating against Ms. Ullman, the plaintiff. If any of you jurors wish to take notes during the trial, you can do so. Some of you may feel that taking notes is helpful, especially in a case such as we are trying here that is complicated. Of course, you aren't required to take notes, and some of you might think it is a distraction and that it might interfere with hearing and seeing all of the evidence. It is up to you to decide about that. But if you do take notes, I suggest you take them sparingly. Keep your notes brief. And please don't try to summarize all of the testimony. Notes are really meant to help a juror remember specific testimony, such as testimony that involves times and dates and distances. Notes can help a juror keep names in mind and the relationships that people in the case may have to one another. You don't want note-taking to distract you from the person who is on the witness stand. Most of your work in this trial must be done with your eyes and ears and your mind, and if you are hunched over scribbling notes, you may miss something important that is happening in the courtroom. Our court reporter is here taking down everything that we say, but she has years of training in order to be able to do that. You are not court reporters trying to take down the testimony of a witness verbatim. Is not going to be possible for you. When you are finally dismissed and go to the jury room, don't use your notes to try to convince other jurors. Your notes are not an official transcript. Only the transcript the reporter produces is official. Whether you take down notes or not, you are to rely on your own memory once you are in. And then we have your second 120 jury charge, capitalized state when you can replace prosecution. And then you have North Carolina, and I think it's NK twice with an asterisk. Yes, okay. This is 120 number 1 for 5 minutes. Number 2, sorry, number 2. The burden here is upon the state to prove guilt beyond a reasonable doubt. This burden never shifts to an accused, for the law never imposes upon an accused in a criminal case the burden or duty of calling any witnesses or offering any evidence. It is not required that the state prove guilt beyond a possible doubt. The test is one of reasonable doubt, and that doubt is based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act. Proof beyond a reasonable doubt, therefore, must be proof of such a convincing nature that a reasonable person would not hesitate to rely and act upon it. The jury will recall that a defendant is not to be convicted on mere surmise or guess. You do not have to believe that the defendant is innocent of the charge against him or her in order to find a verdict of not guilty. Your verdict of not guilty only means that the state has failed to prove to you the guilt of the defendant beyond a reasonable doubt. If the jury, after careful and unbiased review of all the evidence in the case, has a reasonable doubt that the defendant is guilty of the charge, it must acquit. Now, if the jury views the evidence in the case as permitting either of two conclusions, one of innocence, the other of guilt, the jury should adopt the conclusion of innocence. The defendant is a competent witness in his or her own behalf, and you should not ignore or question his or her evidence in whole or in part solely because he or she is on trial charged with a crime. It is the duty of the jury to give his or her evidence the same careful and complete consideration as the evidence of other witnesses, and to weigh his or her evidence by the same rules as you weigh the evidence of other witnesses, and give to his or her evidence such weight and credit as you mitigate, justify, or excuse the commission of the crime. Up to this point, the court has been instructing you as to your duties as jurors and the rules which apply during the trial of every criminal case in the state of North Carolina. Now, I would like to instruct you as to the crime charged in the indictment in this case, and the facts that the state of North Carolina must prove in order to convict the defendant of the charges upon which he or she is being tried. Each material fact needed to prove the offense charged must be proved beyond a reasonable doubt. And if there is a reasonable doubt as to any such fact, you must find the defendant not guilty. It is the duty of the state to allege and prove criminal intent in this case. If from the whole evidence the jury has a reasonable doubt as to whether such intent existed, you should acquit the defendant. You may, but are not required to infer that a person intends to do that which he or she does, or which is the natural and necessary consequence of his or her own acts. Intent may be found by inferences from all the facts and events in the case, provided you are convinced from all such facts and events beyond a reasonable doubt that the defendant had the required intent. You will note that the indictment charges that the offense was committed on or about a certain date. The proof need not say with certainty and that's all you all. Welcome back. Give it your all. There were some fair tests. Type them up and see how you're doing, okay? Have a great day. Don't hesitate to ask me if you have any questions.